Good evening and welcome to this educational session that's brought to you by the Ames Police Department and the Ames branch of the NAACP. Tonight, Commander Jeff and a number of attorneys and others will participate in this activity. As part of tonight, we are asking you to hold your questions, and we have someone who will give you instructions on how the Q&A will go. Vanessa?
Good evening, everybody. I'll be your moderator for this evening. Again, my name is Vanessa Baker-Latimer. For the panel, Jeff will introduce himself tonight, and after the presentation, we'll have a chance for a Q&A. Because this is going to be recorded for future notifications, we want you to come up to the mic and state your name, and you'll be limited to one question, and then please refrain from any detailed remarks. And then if you don't want to come up to the mic, we have index cards that we can hand out where you can ask a question. Also, if you have a future topic that you would like for this to be discussed, please, we'll give you index cards for that as well. And then we thank you for coming, and we'll turn it over to Jeff.
Thank you. I know some of you were here last time. It went pretty well, we thought. And we looked at some topics for tonight's kind of know your rights sort of areas where we want to stick with. And so tonight what we're going to focus on is Miranda is the first topic. And then we're going to talk a little bit about arrests and get into some specifics. And I think Miranda might be one of the most misunderstood court rulings ever, because every time I talk to somebody about Miranda, they really don't understand really what it means or how it applies. And so what I thought we'd start with, a little fun exercise, at least I think it might be fun, is I've got a pretest. So I'm going to hand one out to everybody. We can kind of go through it, and we're going to test your knowledge of Miranda to start, and I can put this side, and then we'll test your knowledge after we're done and see if any of your answers change. Hopefully I got enough for everybody. You better get them all.
No pressure. We have some pencils if you want.
And if you get them all right, then we've all wasted our time. But I don't think that's going to happen. And just a reminder, if you walked in a little bit late, we are recording this, both audio and video. We'll probably end up playing it sometime either on our YouTube channel, Facebook, whatever. So, full disclosure, you're being recorded just like I am. So you can mark them if you want, but we'll go over them kind of out loud since we're recording this. So the first question is, and we'll raise your hand for true or false. The person named Miranda in the Miranda decision had his conviction overturned and went free as a result of a constitutional violation. So if you think that's true, put a hand up. I got some trues. I don't know what you're thinking. How about false? How many people think that's false?
Well, if you don't know.
You can guess. All right. So number 2. I'm not going to give you the answers yet. You're going to hear the answers as we go through this tonight, I hope. Custody always means you have been arrested. How many people think that's true? I see just a few hands. How about false? Don't cheat and look at the attorney either. I don't know if you should even put your hand up.
You don't put your hand up.
So number 3, the police must read your Miranda warning before any questioning. How many people think that is true? I see a lot of hands.
Yeah.
How about false? I see some false, okay. If you're here for the form, you're in the right spot. Come on in.
Sorry, buddy.
It's all right.
Hey, welcome. You failed the quiz.
We're going through the pretest here.
Okay.
You have the right to remain silent. How many people think that's true? See, most hands. How about false? A few people say false. You have an absolute right to resist an unlawful arrest by a peace officer. How many people think that's true? See a hand? How about false? Okay. A police officer must give you the Miranda warning on a traffic stop. How many people think that's true? I want to see any hands. How about false? Everybody else, okay. An officer must read the Miranda warning word for word. How many people think that is true? Got a few hands on that.
I don't even know it.
How about false? That's about half and half on that one. If an officer fails to read someone the Miranda warning, the charges are automatically dropped. How many people think that's true? Not a one of you, okay. That's all right. False? Everybody else, right? The Miranda warning has its roots in the Fifth Amendment. How many people think that's true?
What's the Fifth Amendment?
Give me the answer, yeah. How about false? Sorry, true first. People think that's true. I forgot. We got a few. How about false? And people are guessing. Okay, and this one I'm going to tell you right now is kind of a trick question, but once a person invokes their rights, the police cannot initiate contact again. So once someone says, I'm not going to talk to you, we can't initiate contact with you again. Is that true? I don't see anybody. About false? I see false. Okay. So, that's the pretest. Hopefully, after I get done, you guys will all know the right answers to all of these, except for the one trick question, which is at the end a little bit. So what we're hoping to achieve tonight is to get a better understanding of Miranda and some of the arrest situations, especially when we're talking about unlawful arrest. That's kind of the thing we're going to focus on tonight. So I think we've already explained a little bit how the night will go. I'm going to present some materials. We're going to talk through a few scenarios. If you have a burning question that needs to be answered like immediately, go ahead and put your hand up. I'd rather stop and get something taken care of then. And if not, we'll wait till the end to get to the rest of them. And also, if you have any complaints, if you have like specific officer complaints, you've not been treated right in the past or whatever, it's not a good forum for handling that for me right now because I don't know anything about the situation either. But if you need to talk to me about something, I am the patrol commander here at the Ames Police Department. So if they wear a uniform, they report to me. So I'll leave you a card and we can get in contact and we can take care of any issue that may be, going on later. It's just not a good forum for that here. So the Miranda warning. There was a guy named, I want to make sure I get his first name right, Ernesto Miranda. So that's the guy that the Miranda warning comes from. So I think one of the questions asked about him. Well, Miranda got arrested for rape, assault, and find the other one here, kidnapping, armed robbery. Boy, there's a bunch of stuff. Rape, kidnapping, and armed robbery in Arizona. So he was taken in, and he was not handled very well from the start. The police really didn't do a very good job of handling his situation, and they questioned him when they probably shouldn't have, and they got some information from him, and this thing went all the way to the Supreme Court, and the Supreme Court agreed, and they said, wow, that shouldn't have happened the way it did. We're going to throw out all the information that you got from that questioning because it was illegal, and so they threw all that out. So Miranda, that decision basically made it so they had to retry the case. So they then retried the case, and the second time they convicted him again of the crime, even without his confession. And he went to prison, and then he got out, and Miranda thought he was pretty cool because they have this whole decision named after him, and he was shooting his mouth off in a bar one night, and he got stabbed, and he died. The guy that stabbed him, the police picked him up, and they sat him down to question him, and they put the Miranda warning in front of him that said Miranda warning right on top. And they said, well, we'd like to talk to you. He said, no thanks. And they had to let him go, and he fled to Mexico and was never found. So one of the most famous names in America, Miranda, everybody's heard of him, is a convicted rapist who was murdered. So that's the backstory on Ernesto Miranda, if you were ever wondering. It's kind of interesting. So, what is the Miranda warning? I'm going to read it. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to talk to a lawyer and have them present with you while you're being questioned. If you cannot afford to hire a lawyer, one will be appointed to represent you before any questioning if you wish. You can decide at any time to exercise these rights and not answer any questions or make any statements. Usually after the officer says that, then they'll say, do you understand each of these rights? And having these rights in mind, do you wish to talk with us now? So, do I have to read that word for word? And the answer is no. I just have to get all the main points out of it. So I have to tell you have the right to remain silent. I have to tell you that you don't have to talk to me, that you will have an attorney appointed to represent you if you can't afford one. You can stop answering questions. I just have to hit all those points, but I don't have to read it word for word. Now, what's the best practice? Read it word for word. Because then if I ever go to court and I'm asked what I read or what I said, I pulled a card out of my pocket and I said, I read this and I read this every single time, just to make sure I know that I've gotten all the points. But as a statement of fact, you don't have to read it word for word, you just have to get all the main points out. And I think that was one of the questions. So the other thing about the Miranda warning is the Miranda warning, that case, Arizona versus Miranda, did not give you those rights either. You already had them. What the Miranda decision said is I have to tell you what they are. And that's the big difference. So it didn't give you the rights, it said I have to tell you what your rights are under certain circumstances. So I know there was some questions about here about when I have to give you Miranda. So if I arrest you and I never read your Miranda warning to you, are you going to get that case thrown out? No, because I never have to read your Miranda warning, ever. And in fact, probably 75% of the people that we arrest, we never read the Miranda warning to them. And the reason is it doesn't meet the other criteria that we're going to talk about. So it's not uncommon for people to get arrested to never hear the Miranda warning because we don't need it, I guess. And I'll get to why. So in the Miranda warning, the court specifically outlined the necessary aspects of police warnings to suspects, including warnings of the right to remain silent, the right to have counsel present during interrogations. I completely forgot I had a PowerPoint. Sorry. Let me go back one, make sure I got everybody. These are the folks that kind of helped put this all together tonight. Edna, unfortunately, is not feeling well, so that's why she's not here. Otherwise, she would have been introducing everything. Cheryl is here representing the NAACP, and I think going to do the closing, I think, ish. Maybe not. Okay, I'm getting close. But did help in putting all this together. We met a couple of times to put together what we were going to talk about tonight. Very helpful there. Jessica Reynolds up in the front row. One of the Story County attorneys. She's the first assistant, means she's second in charge over at the county attorney's office. Sean Smith may be late, not sure exactly where he's at. He is a private attorney, did work for the Story County attorney's office at one time. Does a lot of defense work now, so he may or may not show up late. And then me, Howdy. So there was that Miranda warning. Before you leave tonight, I've got copies of it, so you can take one with you if you want, and then you'll have it with you. Okay, so there's basically two criteria for Miranda, and this is probably the most misunderstood part of the whole thing, but there's two things. The first one is interrogation. Interrogation is pretty easy to define for most people. Incriminating questions, right? So if I ask you incriminating questions, you're the focus of an investigation, it's pretty clear that we're talking about interrogation, which is different from an interview. We interview people all the time. We interview people at accidents, witnesses. Those are all the time. Interrogation is slightly different. You're kind of the focus. I want you to say something that incriminates you is what it really gets down to. So it's generally, that's not too difficult to define, not too difficult to decide when that's happening as a general rule. There's a couple of times maybe, but. So here's the big one, it's custody. So custody and interrogation are the two things that if I have both of those, I better give you a Miranda warning. If I don't have one of those, I don't have to, and if I don't have either, obviously I don't have to either. But custody is always the one that becomes questionable. So an arrest, always custody, right? If I say the magic words, you're under arrest, put the handcuffs on you, you're in custody. There's no way around that. If I go out to your house with your permission and say, hey, can I talk to you? And you let me in and we talk and we're having a nice conversation. I said, hey, by the way, why did you kill your wife? And he said, well, I don't know, she didn't make dinner right that night. Like, can I use that? Yep. Was I interrogating you? Yeah. I was asking you an incriminating question. Are you in custody? No, you're in your own house. You could have told me to leave. You could have said, I don't want to talk. So that's why that one works. But there's a whole bunch of gray area in between those, right? In fact, there's a ton. And there are numerous court cases disputing whether or not someone was in custody. Usually, again, interrogation is usually not the focus of those. It's usually whether or not someone was in custody. And police officers make this decision usually pretty quickly. We try and get it right, and then we have, no offense, attorneys and judges and juries that take years to decide whether or not someone was in custody, right? We usually have to make them quicker than that. But that's the system we have, and that's the checks and balances we should
So,
have.
Amanda, what is a common concept of custody? To me, if you're going to be put in a car to be transported someplace, you're in custody.
Maybe.
Well, I mean, but see, that's what I'm saying. The concept of, that means you're not free to just walk away.
And that's the question that is answered by the courts. What they always have to answer is, would a reasonable person believe that they were not free to leave? No, I'm glad you brought it up, because that's exactly right. Would a reasonable person believe that they were free to leave? That's the question the courts have to answer. And we have to be careful of it too. So I've got a couple more examples. We've got the interview room at the PD. And we do this all the time. We bring people down to the station. Sometimes it's in the back of a police car, but we ask for their compliance. Hey, would you go down to the station and answer some questions? Sure. Okay, let's go down to the station. Get to the station, I take you into one of our interview rooms, I leave the door open, I say, hey, you want something to drink? Let me get you a glass of water. By the way, if you want to leave, let us know, we'll give you a ride home. But I'd like to ask you a few questions, is that okay? And you say yes. So we sit down and I ask you questions and you confess to a crime. Is that one going to be good? I'm going to say most of the time, probably yes. Probably. Because would a reasonable person think they're in custody? I told you you weren't. I left the door open. I said you could leave if you want. I'll even give you a ride home. So I think most reasonable people would say, yeah, it's probably not. Same scenario. Now I put you in that room and I close the door and it's locked. And I say, well, we're going to have a little talk here about what happened. And I start asking you incriminating questions. Now are you in custody? I think some reasonable people would probably at that point say, I don't think I was free to leave anymore. The door was locked. The lights were really hot in the room. The officer kept touching his gun. I was a little scared. Probably then I'm going to say you were in custody at that point. So great question. The traffic stop. Yes, ma'am.
Wait, I'm confused. You're saying if someone's in custody and if they're arrested, they have to be read their Miranda rights, but if they're not in custody, they don't have to be read?
Don't worry about the arrest part. It's custody and interrogation. If those two things are aligned, so I'm asking you incriminating questions and you're no longer free to leave, as a general rule, that means I should give you a Miranda warning. And the remedy, if I don't, is I can't use what you said against you. We don't just drop the charge. It's just like in the Miranda case, actually. They couldn't use his confession, but he actually still got convicted because there was other evidence. But so arrest is always custody, but there's other forms of custody that don't meet the standard of arrest, like we just talked about with the locked room. Even sometimes the back seat of a car, if I shut the door and I'm talking to you through the window and I'm not letting you leave and I make it pretty clear you're not free to leave, that's probably custody at that point.
But
Does that make
you
sense?
wouldn't have to read their Miranda rights to them in that case?
Yes,
You would.
I should.
So it's either or.
I'm sorry, I'm not following.
Yeah, both. Custodial interrogation.
Yep. If one of those things doesn't exist, I don't ever have to give you Miranda. So if you're not in custody, like if we're standing out on the side of the road, just having a conversation, and I'm asking you incriminating questions, you're really not in custody, because you can walk away. But once I make it so that you don't feel like you're free to leave anymore, that's when I should start thinking about giving you Miranda warning. And what we teach our officers is if it's kind of, you're not sure, give it to them. Because you can't be wrong giving somebody the Miranda warning, right? You can never be wrong. I could give it to every single person I talk to on the street. I could walk up and say, hey, the weather's nice today. By the way, you have the right to remain silent. I can do that. We just don't. So it's those two criteria. The next one up there is traffic stops. So traffic stops, what do you think? Do I Mirandize people on every traffic stop?
No.
I see a lot of people shaking their head because they know we don't do it, right? And why is that?
You're not in custody.
And that's what the courts have said. The courts have basically said that a traffic stop is kind of a routine thing. The expectation is we're going to finish our business, you're going to get a ticket or a warning or get chewed out or not or whatever, and then you're going to be on your merry way and so am I. So the courts have said basically those aren't custodial. There may be interrogation happening. You know, I'm going to ask you incriminating questions sometimes. Did you know you were going 40 miles over the speed limit? So yeah, I might ask you an incriminating question. But technically, the courts have determined that that's not necessarily custody. Does that one make sense? Okay, because most people have been stopped before and they know we didn't read them Miranda. So then I've got this OWI public intoxication sobriety test. We get this one that comes up occasionally. So when we stop you for driving and swerving all over the road, you've had a few too many beers, or the occasional person out in campus town maybe that's had too many drinks, and we stop you and say, hey, we need to check and see how you're doing here, and I want to run you through this series of tests. Do I have to Mirandize you for that?
No.
No, again, no. And the reason is you're not really free to leave so much, because I'm going to tell you you're going to do these tests or we're going to figure something else out. So I think the free to leave thing is probably either questionable or you're not. Am I asking you incriminating questions?
Yes.
Probably. Yes.
Not really. What I'm doing is called a non-testimonial. I'm going to test your balance. I'm going to look at your eyes. I may have you say the alphabet, but I'm not asking you a question. And so those are called non-testimonials. So I don't have to Mirandize you because it's not the incriminating questions. I'm determining based on tests how you did, and that's different than an interrogation. That one's a little bit weird, but mostly what you're doing is I'm looking at physical things. Miranda only covers testimony. So it only covers what I'm saying, it doesn't cover what I'm doing. So I'm going to check and see if you can walk a straight line, if your eyes look okay, if you can recite the alphabet maybe. There's other tests we do, but those are called non-testimonials. Yes?
Now, if you say, I think you've had too much to drink, go ahead and try and walk this line. Is that question in them? Because you're expressing an opinion that,
But I haven't asked you anything.
yeah.
I mean, I've said before, you think you've had too much? Yeah. Well, let's do some tests. So, and there could be an argument about whether you're really in custody or not either at that point. I don't know if we have a good decision on that. Do you?
So I think that the closer they get to asking you how many drinks, usually we wait and do that after we do our field sobriety test. Because I think when they start saying how much you had to drink, those kinds of things, then you're getting closer to the interrogation part of it. And I think there's a good argument that you're in custody, depending on the facts and circumstances and how, what they've told you and where you're at, if you feel free to leave. But I think it's really that it's not interrogation at that point, it's observations. So it's just like if the officer's watching you walk down the street and you're falling around, they're not interrogating you, they're making observations of your physical characteristics.
I want to see if I covered everything that was on the pretest here.
Where'd it come from? Number nine.
Yeah. I guess I didn't put that in here. So the Fifth Amendment is the right against self-incrimination. And so you don't have to, yeah, right. I can't compel you to testify against yourself, so that's where kind of the roots of the Miranda comes from, is that I can't compel you to basically testify against yourself. I think we hit most of it. So this, once a person invokes their rights, the police cannot initiate contact again. That's sort of a trick question depending on what you mean. So if I walk into the room and I say, Commander Hoff, I'd like to ask you a few questions, you have the right to remain silent, yada, 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 and I go through all that, and you say, yeah, I don't really want to talk to you. Okay. You say, I want to talk to my attorney. Okay. So I walk out of the room. Get another officer, say, hey, go in there and try again. You go read them Miranda and see if they'll talk to you. So that other officer walks in and they do the whole thing, and you go, all right, fine, I'll talk to you. Is that going to hold up? No, it's not. Can't do that. Once you've invoked your rights, I can't try and reinitiate that contact and trick you into talking to me. Now, the caveat on why this is a trick question is that doesn't last for the rest of your life. Okay? So if at one point the police stopped you and you said, I don't want to talk to you, I want an attorney, and a year from now, if I stop you again, that doesn't count. Okay, then we're starting over. So there are times when we can reinitiate, but we're really not reinitiating that same contact. It's a whole different thing. What does the law say about a different crime? I didn't put that in here, but that's a great...
that is a really good question. So, depending on whether or not, if you were questioning at the same time and they invoked that right, then you couldn't, I want to talk about this because they've invoked that right. But we have this come up a lot with people who maybe get arrested for one crime and invoke and get put in jail, and then we start investigating a separate incident. We can go back about that separate incident and ask if they'd be willing to talk to us about that separate incident at a different time. And we would have to read Miranda because it's custodial interrogation, and they could agree to talk to us about that separate incident, or they could say no again, which would be fine. And the other thing it brings up for me, which is always interesting, is if, let's say you invoke your right to remain silent and say, I'd like an attorney, and then you sit there and think about it, the officer leaves okay, and it's maybe doing paperwork, and you say, you know what, I do want to talk, I changed my mind. You can do that. So you, as long as the officer doesn't solicit it, you can say, he doesn't have to go, no, you invoked your right, so I can't talk to you about anything. And we do see that every now and then, especially maybe riding in the squad car in jail, and they'll maybe make extemporaneous statements or want to engage the officer. And as long as the officer isn't the one that is really engaging it, then that is acceptable. Which
Comes up every once in a while. Another one that comes up is the completely unsolicited confession. So we may have arrested you, or at least have you in custody in the back of the car, and we may be headed to the station, and we have people that will start telling us stuff. Now, we're not required to stop them and say, oh, whoa, before you say that, you have the right to remain silent, because I didn't ask you anything, and I'm not compelling you to speak. So if you just want to blab about it, that's kind of on you, and I'd be able to use that against you if I wanted to. And that one actually happens from time to time, where people will just, for whatever reason, they get bored on that car ride, and they'll just start telling you stuff, which I'll just keep my mouth shut and let you talk. Trust me, I'm not going to stop you and Mirandize you at that point. So then the question sometimes that comes up is, if you can never be wrong giving somebody their Miranda warning, then why wouldn't you just give it to them all the time? And to be honest with you, if we don't think that we have both of those two things, the custody and the interrogation part, sometimes we think people aren't going to talk to us if we give them a Miranda warning. And so if we don't think it's required, sometimes we just won't to see if you'll talk to us. And then we have to be careful at some point during that. We have to be careful that things haven't changed significantly enough that you now are usually it's the custody part. So we got to be careful that during the course of this, our conversation, if we get to the point where you're now in custody, then we better stop things and do Miranda. And the other thing is important about what a reasonable person thinks they're in custody. It doesn't matter whether they, how do I word this? I may think you're in custody as the police officer. I may think you're not free to leave, but as long as you think you're free to leave, that's what counts to the courts. It's what a reasonable person thinks. So even if I know there is no way this person's going to walk out of this room after we talk, I'm going to charge them with something. If they don't know that and they think they're free to leave, then you're still okay. Does that make sense?
How would you know what they think, though?
I'm sorry?
How would you know what they think?
Well, I gave an example earlier. It might have been before you guys walked in, and that's okay. Where I may take you into an interview room and leave the door open and not lock it and say, hey, if you want to leave, let me know.
Okay.
All those kind of things. And so most reasonable people would think they're free to leave. Even if I may know a lot more about what's going on and know you're not going to be leaving, this is over, I got a good charge. But we have to be careful with that because I don't want to get it wrong and lose that either. So again, we're going to go back to if it's kind of like, I'm not sure, then give it to them and just be right.
Okay. Thank you.
You bet. And then I want to move on to the next subject. This is actually going quicker than I expected, so Edna would be happy. She likes to stay on time. So this was actually question number 5. Do you have the right to resist an unlawful arrest by a police officer? And I think most of you said no, I think there was a couple of yeses. So I'll ask again, how many people think yes, you can resist an unlawful arrest?
That's what I have to.
Okay, at least one. Everybody else is saying no? Most of you are right, sorry.
Okay.
And this is why. Iowa Code 804.12 basically says you do not have the right to resist arrest, even if it's an unlawful arrest. So that, you say it to most people and they go, that doesn't make any sense. Why can't I resist an unlawful arrest? Well, the reason is not because we're out there making a lot of unlawful arrests. The reason is we can't leave it up to every individual person to decide for themselves whether they think the arrest that's being made is lawful or not. Because most people we arrest will go, I didn't do anything wrong, right? So if we had to fight with people every time, that's kind of what The first part's about officer safety, right? Everybody thinks that they're wrongly accused and I didn't do anything wrong. So we don't want to duke it out with every single person that we encounter, right? And then the second part of that is that's not the place for the debate. The debate should take place in the courtroom. So before the judge, before the jury, with the attorneys present. So, and then again, I don't want you to come away with we make a lot of unlawful arrests, because we don't. But the reason it's there is for that reason. We don't want to get into this debate and get into the position where somebody's going to get hurt, whether us or you or whoever, because you don't think what you did was wrong. Really don't want that to happen.
Since this is going to be broadcast, will that slide presentation also be available?
Yep.
Because otherwise, we would want to read what the content.
No, let me read it just to make sure, but I'm pretty sure he's going to clean that up.
Okay.
So I'm going to go back to the use of force in a resisting arrest, 804.12. A person is not authorized to use force to resist an arrest, either of the person himself or another person the person knows is being made, either by a peace officer or by a private person summoned and directed by a peace officer to make the arrest, even if the person believes that the arrest is unlawful or the arrest is in fact unlawful. So technically speaking, if I arrest you for no reason and you resist, and we get into a fight, you could have additional charges that will still stand up, even though the original thing falls. Now, in most cases, if that happens, they're going to drop all the charges. If I make a completely bogus arrest and you resist it, likely the county attorney is going to throw the whole case away because it's bad to begin with. But technically speaking, they wouldn't have to, because anything that you did that was unlawful, if you resisted arrest, if there's interference, whatever, those would still hold up because of this. And again, that doesn't happen very often. I can't say never, obviously, but not very often. So the reasons were, first, officers' safety is a paramount consideration. People often think their arrests are unlawful or unfair. If citizens then had the right to duke it out with law enforcement every time they held that belief, then a lot of officers and a lot of citizens would be hurt. So that's what that slide said. And then the second one, the streets are not the time or place for debate on the legality of an arrest or whether the arrestee has committed a crime. Those are matters to be determined in the courtroom by judges and juries. So at the end of the day, the advice I give everybody is, if once the officer says you're under arrest, just comply. And if you believe you've been treated poorly, if you believe the arrest to be unlawful, we have a process to handle that. You know, you can call in, talk to a supervisor, talk to the county attorney's office, city attorney's office, whoever, and we'll work through those issues. It's just never a good idea to kind of get into it at the scene, because usually what happens is you end up getting charged with more things. And you had a question.
What constitutes resisting arrest?
If I say you're under arrest, and I'm going to tell you, turn around, put your hands behind your back. If you kind of don't do that, then you're going to start resisting. There's different levels of resisting. There's kind of like, I'm just not going to put my hands behind my back. I'm going to stand there like this.
That's resisting?
Kidding me. I'm giving you an order, and it's lawful. I have a lawful reason to do it, being you've committed a crime either in my presence or I can prove it by probable cause. Yeah, because eventually if you do this, I'm going to say, well, you can either put your hands behind your back or I'm going to do it for you, and I'm going to walk up and I'm going to have to put hands on you. Then if you pull away, that's also resisting. So if you really don't comply, it's some level of resisting. There's different levels. There's interference with official actions, harassment of a public official, what else? Well, there is a charge of resisting arrest too. So there's a lot of different things. So really, once the officer says you're under arrest, put your hands behind your back, that's what you should do. Make it easy for us, make it easy for you. Then nobody gets hurt, and we'll deal with the ramifications either way after the fact. Like I said, if you think what happened was bad, if you were treated poorly, even if you did whatever it is, and you just don't like the way the officer treated you or didn't treat you with respect during that, we still want to know about it because we'll investigate it. I think I saw a hand.
It's my understanding that arrest records are kept. They're not purged. And I believe there was legislation posed last legislative session in Iowa to do that. So people, and it influences people's opportunities to get jobs, to get housing and so on, because those records of arrests, even if not charged, are kept. That's my understanding.
Yeah, and
Do you have to repeat the question?
oh boy, if I can.
Oh, no.
Basically what she was asking is records of arrest basically last forever and are not purged from the system. Is that
On the Iowa court system.
right? And that's true, and they're all public records as well. So anybody can look at Iowa courts online and look at anybody's arrest records. So yes, that's pretty much true. You can have some records expunged, but that's kind of beyond my scope of knowledge. I don't know if you know any more about.
Speak a little bit to that. Yeah, that is a.
Yeah, there we go. I keep forgetting the microphones.
That is a serious issue that we see, and there are certain even convictions that can be expunged. And so this is dealing with after you've been through the process, if you've been found either have pled guilty and got what's called a deferred judgment, which means the court doesn't enter sentence or judgment but puts you on probation. And if you complete terms and conditions of probation, then judgment is deferred or not entered. And you can request that that be expunged from your record. And if the court grants that, then that comes off of Iowa Courts Online. But an issue that has arisen is that stays on your background check, what we call your Ncic background check. And a lot of employers will request that you sign a waiver when you apply for a job that says that they can run that background check. And so even though that's officially expunged and taken off of the court records, there are still ways to get at that. However, arrest records do show. And so, you can get on Iowa Courts Online, you can see there was an arrest, even if there was a dismissal, that still does show there. So I think that in our technological age, it's a really big concern, and hopefully the legislature will continue to address it, because the whole point of deferred judgments is that people are given a chance in circumstances where they don't have a criminal history, it wasn't a violent crime, to have that not impact their future. And I think with the current state of events where employers request that waiver and then that information is accessible, it's a problem. And same thing with arrest records or dismissals. I think that's something the legislature is considering as well. When something's dismissed, should that show up when someone does a search of your name? So talk to your local legislators about that.
Some of us went to University of Northern Iowa about, what was that, 2-3 weeks ago?
Yeah.
For the criminal justice forum. And that was another topic that came up is, at what point have you repaid your debt and you can quit repaying it? And that was one of the topics that came up, was employment especially, where you've served your time, you've paid your fines, whatever, and now you go to get a job and this thing is still on your record and it's making it awful difficult for you to do anything but the thing that probably got you in trouble in the first place. So we're starting to see a lot of discussion about issues like that. And it was pretty interesting to hear some personal stories from people from that group. I got a lot out of it. I'm glad I didn't make me go. And we got to ride on the party bus too. I'm just going to leave that one right where it's at. Use your imagination.
Sorry, I had something else. You can take the microphone from me. Something the legislature has recently addressed that I think has assisted with particularly college students and young people is public intoxication charges, and then what we call PALAs, or possession of alcohol under the legal age. So, if you possess a beer and you're 20, not 21, those crimes now, if you go for 2 years without any further law violations, can be expunged from your record. And so I think that has assisted, but again, we get back into the situation where even if it's expunged, is it accessible in some way? So I think the fact that the legislature took a recent action on those crimes shows that they're aware that these things do stay with, to me, that really helps students that are in college. But again, we've got this issue about it being accessible through their FBI and Ncic background check.
Right, now we can go through the post test. The 10 questions again, and let's see if we get them all right, and then I'll know if I did my job or not. Lieutenant Walter has also joined us in the back of the room, if he wants to raise his hand there.
Do I get in trouble?
Yeah. Dan is one of our shift lieutenants, so he's one of the shift commanders, so he's in charge of the 3 to 11 shift. So everything that happens between 3 p.m. and 11 p.m. he either gets credit for or is his fault.
Now we know.
And the parking, don't forget the parking.
And that's right, he's also the parking assistant manager, so he gets to listen to all the parking complaints. And he's a good egg, so thanks for coming on. All right, so number 1, the person named Miranda in the Miranda decision had his conviction overturned and went free as a result of a constitutional violation.
False.
False. Okay, great. Custody always means you have been arrested. False. Could be a lot of things. The police must read a Miranda warning before any questioning. False. You have the right to remain silent. True. None of you used it right there. You have an absolute right to resist an unlawful arrest by a peace officer.
False.
Police officer must give you the Miranda warning on a traffic stop.
False.
An officer must read the Miranda warning word for word. False. Should probably read it word for word, but technically don't have to. If an officer fails to read someone the Miranda warning, the charges are automatically dropped.
False.
The Miranda warning has its roots in the Fifth Amendment.
True.
And this is the trick question. So I did put sometimes, but once a person invokes their rights, the police cannot initiate contact again. Sometimes true, but not always.
So in this case, it's false, though.
Yeah. It's kind of false.
In this case, it's false.
That's right.
Because we want to get that answer correct.
You didn't go to my.
So I must have at least done a halfway good job because everybody got them right on the second time through. And hopefully you, from start to finish there, saw why and how things work the way they work. Because I know on the pre-test, we weren't quite 100%, but we were on the post-test. So we've got time for questions. We've got a lot of time for questions. I'll stay as late as you guys want to talk. And Jessica's here from the county attorney's office, and if there's something that I can't answer and she should be answering, I'm going to let her answer it too. And I'm going to make her come up here because we want to make sure we get her on the mic. All right? So if you got any questions, feel free. It doesn't necessarily have to be about Miranda or the resisting arrest stuff. If you got other questions, we can take some of those. Yes?
Oh my gosh. I think I speak loud enough.
I'll make Derek get us a wireless mic next time, and it'll be a little easier to pass it around. And don't try and stump me either.
No, I'm just reminding you about one other area that we discussed and you didn't mention, and I didn't know if we had kind of put that on hold.
What was it?
The conversation, the one, and I see my thing is over there. The one party.
Oh, yeah. I threw out the recording because I thought we were going to be long on time, but we're not, so I can throw it in real quick. When we're talking about recordings, like body-worn cameras or anything else, Iowa is what's called a one-party consent state, which means only one of the parties needs to know that that conversation is being recorded. Illinois is a two-party consent state, but Iowa is a one-party. So what that means is, if I have a body camera, which we don't have them yet, we will likely have them in the next 6 to 12 months, but when we do have those, I never have to tell anybody they're being recorded. And the reason is because I know. I'm the consenting person, so I know that's being recorded. Another thing we may do is make a phone call to somebody and record a conversation, right? When we do that, it's still okay, even if you don't know it's being recorded, because I do again. And that's that one-party consent. And so I think it's important to know this. Now, that is not an absolute right, though. If I put a camera in a public bathroom and record it, I know it's being recorded, right? Because I'm the dirtbag that did it. But that doesn't work. That's clearly against the law. So this is specifically talking about recording things that are legal, I guess. And it does come up from time to time. I record conversations on my telephone in my office, especially when people call to make complaints, because I like to have a record of that when they come in. All 911 lines that come into the police department are recorded. All non-emergency lines are also recorded. So if you call the 239-5133 line, that's recorded. And those are recorded for a lot of reasons. One, it could be for evidentiary value later. Somebody can say something that becomes very important in a court case. Excited utterances and things like that that we may not be able to use otherwise. And also, it gives us a chance to record and listen again to make sure we got something right. Sometimes people are really excited when they call in, and our dispatchers will quickly rewind something, listen to it again to make sure they got the right address or make sure they got the right name or whatever. So there's a lot of reasons they record those. And so that was just something I wanted to point out because I don't think a lot of people have ever thought about it before, but Iowa is still a one-party consent. I don't know what they would do in Illinois with a body-worn camera if they have to tell everybody that they're being recorded when they're out?
Good question.
I have no idea how that works.
I don't know either.
Maybe it's so readily apparent that you don't have to, I don't know, but, and, you know, we've had cameras in our patrol cars for, I don't know, probably 20 years now, 18, 19, 20 years. And we've never, on a traffic stop, walked up and said, hey, by the way, I just want you to know you're being recorded. Right? I think most people probably figure they are anyway. Yes?
So you could have a third party call somebody, say a friend, right? And you could record it.
As long as one of the parties being recorded knows and consents.
Okay.
So one of the parties being recorded has to be a
It's
consent.
probably, I mean, I'm sure the police does that, where they'll have a friend, call a friend, and you'll record that conversation.
So we'll ask someone
Yes.
to call someone? Yeah, it's okay as long as that person that's making the phone call that we've asked to call knows that it's
That's
being recorded.
consent, okay.
Yeah. Otherwise, then you're getting into wiretapping and stuff. If I'm recording it and neither party knows, I can't consent, especially as law enforcement, I can't consent to recording two other people that don't know it. Because I'm not the one
That would
being
be my next
recorded.
question then, can you record two other conversations if you don't?
No.
The answer's no, okay.
No.
That's
The
wire-
consent part is-
And that's wiretapping.
Yeah, I mean,
Yeah.
that's kind of outside my area too, but generally that's where you're going to be at. That's going to be illegal. The consent part means one of the people being recorded is consenting and knows it's happening. So that's why it's okay if I say, I want you to call her and I want you to record that conversation and I'm gonna listen to it. I may even use it as law enforcement. As long as you're okay with it, it's
Does
okay.
that apply to online conversations, like instant messaging? Could you instant message somebody, record it as a police officer, knowing that would that be consent?
I think if one of the people involved in it was consenting, yes. And in something like that, you could also subpoena records without consent of either party. So if and I don't know how I would know this if it didn't happen, but if I somehow knew that you were having a conversation with somebody by text message, let's say, and you were talking about something that was illegal, and I found out that this was happening, I could try and get a search warrant and subpoena those records and get them that way, but that would be different than what we're talking about. Good question. I didn't think I'd get into wiretapping tonight. That's like the FBI.
Well, the federal government does it anyway.
Yeah,
They don't tell us.
they were probably recording
Everything's
everything.
recorded.
I just wish they'd pay my cell phone bill to listen to it. Any other questions?
Let somebody else speak, I'll come up last.
Do you want us to say our name?
That's up to you.
It's up to you. I will. I'm Gail Siler, and I am with KHOI Radio, but I'm also in the School of Education at ISU. So I'm interested in education, so my question is related to schools in light of the recent incident in Columbia, South Carolina. And I'm new to Ames, so I don't know the answer to this. What is the relationship between the security and security officers or security system and disciplinary policies and processes in the Ames schools, resource officers, and the Ames police?
Well, we have, and if I don't answer your question, hit me, but we have one school resource officer for the city, unfortunately only one. He spends about 75% of his time or so at the high school, about 25% of his time at the middle school, and very little at the elementary schools because he kind of has to go where the issues are. His position is funded partially by the school district. They pay, I don't know the exact amount, it's less than half of an officer, but it's around that. So they're paying a little less than half of the salary for that position. And then basically his job is to liaison with all of the schools. He does investigate crimes that happen inside the school, but the schools still have the discretion to handle whatever they want to handle kind of internally by their policy. I'm not sure if that was what you're asking, but the schools, if they have some rule violation or whatever, they can handle that however they want to handle it. If it becomes criminal, they then may have the school resource officer kind of get involved and handle the criminal part of it, which may include a citation, and sometimes not, sometimes just getting the parents involved and whatever else. Is that what you're asking, or am I missing it?
Yeah, I mean, that gets added. I'm just interested in, the extent to which what used to be handled internally by schools in terms of discipline is becoming criminalized. and how much that is happening here.
Sure, now, okay, now I see what you're saying. Our schools, at least in Ames, tend to try and handle things internally, getting parents and counselors involved to deal with the problems, because we don't really want to put labels on people when they're young like that. But we've had cases and occasions that have come up where it can't be avoided. There's something that happens, it's something that has to be handled through the juvenile court system. And it's usually juvenile court. We do have some people that are adults in high school when they turn 18, but generally it's juvenile court that's going to get involved. And that's actually not a terrible system to be in. The juvenile court system, their goal is really even more than the adult system, is rehabilitation and services. So they're going to want to get that child whatever services to solve whatever problem it is. So sometimes it's getting DHS involved. It may be, drug evaluation and counseling or whatever, because a lot of the problems that we encounter are those kind of issues. And so if you get the right people on the front end to help solve them, then we may not see that person ever get into the adult system, which is our goal, is not to get them in the adult system. And that's why we have a school resource officer to start with. I wish we had 2, but right now we have 1.
Just one more follow-up, sorry. Is there data available on the number of arrests that take place in schools?
Well, a juvenile is never arrested. They're detained and adjudicated, just a different language that we use. I'm sure there is. I mean, we keep data on everything, so every ticket we write, every arrest we make. So yes, it would probably be available. It's probably a little tough to get at in the form it's in, because it wouldn't be separated from anything else. So when I say that, I mean, I don't know, if I wanted to look for all juvenile referrals, I'm gonna get all juvenile referrals, whether it happened in the high school, the middle school, or at Walmart, you know what I mean? Or at one of the other juvenile houses around town. So it's sort of hard sometimes to separate things into this occurred in this specific location, this occurred in this specific location. We could probably do it, it'd just be a little time consuming to go through. I mean, clearly you can address, so we can address the high school, but again, where something happened is not always where it happened in our system. So you may have an incident that happens at the high school, we don't find out about it till later, so we go to your house to deal with it, and that's the address that's on the information. And so it wouldn't technically come back to the high school or the middle school or whatever. Does that make sense? People think our records are better than they are. I'll be the first to admit it. I wish we could do some of the things people want us to do with our records, but they're good, but they're not that good. Sometimes it's really hard to pick.
Jeff, if I could just add just one quick thing to that. I would add that it's very, very seldom that we actually take somebody away from the school. There might be some citations there, or there might be some where we issue a juvenile referral, but as far as arresting somebody or taking them away in a squad car, very, very seldom. I might not be allowed. Very, very seldom that happens. I can't think of an incident in the past year where my shift has done that. So that's the good news.
And just like everything else, there's usually a small number of, in this case, kids that cause most of the problems. So there's not a lot of problems. There's just a few kids that tend to kind of get in trouble a lot. And so we're trying to divert them into other things so they don't end up in the criminal justice system, but we're not always successful, unfortunately.
Wayne Clinton, I'm speaking as an individual citizen here. I've served on the State Juvenile Justice Advisory Council for several years, and most recently I was chair of the DMC committee looking at disproportionality of African Americans in the juvenile justice system. We tried to work with some of our major cities and school districts to get data on the number of arrests, the number of referrals through detention. That is the most difficult thing for schools to release. There is currently nothing out there that says that they have to give you that data or that information. What we tried to do was try to get an aggregate total of the types of referrals that are made. There are some school districts, and I'm glad to hear that it's not true in Ames, that the resource officers has become the disciplinarian, because some teachers feel an unruly, disruptive student they can't handle, and so they are immediately referred to the resource officer, who in turn now becomes the disciplinarian. And then ultimately, if for some reason that escalates and that child is removed from the school and then referred to the juvenile justice system, now you've got a case that is going to be much more damaging to him or her.
That's why I'm asking.
And that's one of the real issues that we're trying to talk to not only our schools, but our resource officers as well. Where's the line in terms of determining what type of behavior is where you need to get involved versus having the school personnel step in and try to deal with that. And that's a real tough issue, but it's more prevalent in most of our major larger cities than it currently is in our community. And I can tell you from statistics, we've fought that for years, and trying that the Annie Casey Foundation has been working with us, and Woodbury County has been one of the more cooperative ones, Davenport, Polk County, and in trying to address some of these issues. We're making headway. Johnson County is another one where we're making some headway, but the statistics are just not there. I believe we were at, in the forum that Commander Huff spoke about, some of the topics and discussions came about, and getting data and getting the necessary information. Almost everything today, in order to change the system, you've almost got to have data, so that the legislators and the policymakers recognize there is a problem. And if that is not made available, it's very difficult to affect system change. So I think as a community, we need to find a way to just work with our local school systems, work with local law enforcement, work with the juvenile justice system in terms of how are our youth being treated in certain behavior or disruptive type situations, which, and in most cases, through that type of dialogue, I think it's, we're going to find less and less major issues where they're referred to the juvenile justice system.
That does remind me, I think I get a little bit even more what you're asking. Our school resource officer does more with education. So, you know, the reason he's there is to help with programming. Obviously, he has to step in and do law enforcement when it's there, but most of what he does is the education component. But it's true, in some bigger districts, the school resource officers are security for the school, you know, to keep order. That's not what ours really does. We still expect the school to do the bulk of that. Now, when we have somebody that's really out of control, dangerous, you know, clearly he's going to step in and handle those, but that's few and far between. It's a good district. And it's a good working relationship. It's nice to have a school district that thinks so much of the school resource program that they're willing to put money behind it, you know, and pay some of the salary for it. So that's awesome.
And I'd like to piggyback on that, Jeff. I've been out of the school system for 5 years now, but I was here in Ames for 20 years. And I was a school counselor at the elementary level, but we also kind of overlapped with middle school. And I can only remember one time when I called and the resource officer went with me, and the issue was on truancy. Mm-hmm. And we sat down and we spoke with the parent. And you were very, I don't know how much things have changed, but we were very connected to families. If there was an issue, counselors, or at that time we were called family resource counselors, we went to the homes and we were very aware of situations that were going on, and we knew people, we knew the families. And we also let the children know, okay, if this is happening at school, we'll be at your house at such and such a time. So a lot of the issues that you see maybe in major metropolitan areas, we didn't experience those things as much here. But I don't know how much has changed over the years, but we had really good working relationships with people.
You probably had Brooke McPherson at that time, right? Yeah.
But there was a lady then at that
Yep.
time that we had,
Yep.
yes.
Brooke cycled out of that position about a year ago, I think, a year and a half ago, and now it's Nick Schiefer, and both of them do an excellent job.
I was just gonna piggyback on the
Maybe this is the topic we should start with.
on the issue of data, and I'm sorry I didn't get to come to the first one. I didn't know about it, but it was evidently about traffic stops, and so that's one I read in the Des Moines Register that Ames doesn't keep records as far as race went for traffic stops, and I was wondering if other cities do, and, you know, if there is a problem with disproportionate arrests of black people or people of color in general, we wouldn't know about it because we don't have the data. So I was just wondering, is there a philosophy about not taking that data, or is it just never done it, never, I don't know.
We do have the data.
You do?
Oh, yeah.
So the Des Moines Register was wrong?
Imagine that. That's all I'll say about it. We have an electronic system that we write our tickets on. So if you're talking about traffic stops that
result in tickets.
That result in tickets. We have no system that easily processes race, at least, from just a traffic stop where there's no paper. So if I stop you and give you a verbal warning only, then probably not. If I stop you and give you a warning or a written citation, then there's absolutely, it captures everything. It's going to get your name, your address, your date of birth, your social, well, not social, your DL number, race, height, weight, all that stuff. So it's that information we do have. I'm guessing if the Des Moines Register said we don't have it, they mean we don't have it if we don't put any paper on it to stop.
For just a stop.
But on the flip side, everything we do as a police officer involves an event number, so a call for service. So if I do a traffic stop on somebody and I just give them a verbal warning and say, hey, slow down or whatever, there's still a record that incident occurred. And usually what's on that record is going to be your license plate and probably your DL number, unless it was so minor I didn't even bother to get that stuff. But that's probably not the norm. There would at least be the plate number and maybe the DL number. And you could go back and then figure it out, I suppose, but it would be a lot of work. And I can tell you also, we don't get a lot of complaints. So not that complaints are the thing that drives whether or not you have an issue or not, but we don't regularly have people coming in and making complaints about almost anything, really. So, you know, that's not the only barometer of how you're doing, but it is one. And so we do feel pretty good that we don't have, you know, people consistently coming in here feeling like they weren't treated very well. And when we do have those incidents, we do investigate them fully, and we include the person that's making the complaint in that process, and then certainly let them know the outcome of that investigation. And then if they don't like that, there's other places they can go to. We always like to start at our level so we can investigate it. And we've made mistakes before too, and we'll own up to them when we made a mistake, and it happens occasionally. We're not perfect. Dan is. Dan's perfect. I wish.
That's on the record.
Well, one of the comments, I was in wake of what we just saw on the TV the last few days with this school, there was a group on the TV talking about one of the most important takeaways, and you touched on earlier, that when you're stopped by a police officer, you should probably just obey whatever the command is. That is the best way to diffuse any potential situation that you might get in, even if you think there was no reason whatsoever to be stopped. And if for some reason it was handled poorly, that's where the lawyers will step in to deal with it. But it could diffuse a lot of things. And I wonder a lot in your training, a lot of times in a college town, you've got people under the influence quite often. And they don't always think or act properly in those type of situations. So how do you work with your officers in terms of trying to diffuse some of those individuals who might want to be a little testy? Right. You know.
We certainly don't like fighting with people, because usually what happens is somebody gets hurt, and sometimes it's us. And we've got 2 officers right now that are out on injury leave. One of them was actually a training injury, and the other one was chased the suspect who had stolen a bike and somehow caught him, not sure how. And the suspect basically pushed him, tripped him, he fell off a retaining wall, and he had surgery. He's out for 6 months. So one of the things we do work on is de-escalation training with the officers. One of the training sessions we use is called verbal judo. So it's basically a system of trying to de-escalate a situation using your voice, using your words, to try and calm something down, so we don't get to the point of having to put hands on, because that's the last thing we want to do is put hands on, because again, somebody usually ends up getting hurt, either on purpose or on accident, and we don't like that either way. It's very costly to have an officer for 6 months. We paid for the surgery, obviously. Actually, we didn't. You did. You're a taxpayer.
Yep.
So you taxpayers paid for the surgery, and you're going to pay for him kind of not to be doing his job for 6 months while we're waiting for him to heal. And there's a bad guy out there responsible for it, and we'll probably never get the compensation out of that person for what happened. But yeah, it's in people that are impaired especially. It's a little harder to reason with someone that's being unreasonable, but we try, so we don't have to use force. It doesn't always work. It's a college town. There's some tough young kids out there. I'm not one of them anymore. Anything else?
The questions about other topics that you mentioned earlier, if anyone has any of those, as we have future sessions, who do they turn those into?
Our moderator will finish up.
Please let's give Commander Huff a round of applause. Assistant County Attorney Jessica Reynolds for her input as well. And you as the audience, and thanking the NAACP and the Ames Police Department for putting this together. We do have index cards that we would like to pass out. If there are some future topics that you would like for us to cover in this forum, I think this has been a good opportunity to get questions answered, and also putting it on the video so that we can replay it for broadcast. For again, education is always important. And the more we can educate and ask questions and get clarifications, the better off we are as citizens on both sides of being on the police department or being in the community. So again, thank you all for coming and appreciate it. Have a great night.
Thank you.
Thank you.